Good morning. Welcome to an oral argument. Can everyone hear me?
Yes, sir.
Okay. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eisnagel. I'm being joined today on the panel by Judge Harris and Judge McIver. We are here for our first case is the 10 o'clock case, 23-485 Stafford versus State, correct?
Correct.
All right, very good. So for the appellant, if you'll let me know how much time you'd like in rebuttal, we'll try to help you remember. It's your responsibility to watch the clock, but.
5 minutes would be sufficient for rebuttal, Your Honor.
Okay, I'll try to help you watch the clock, but at the end of the day, when you hit 5 minutes, you need to recognize it if I miss it. Even though we're on Zoom here, I highly recommend that you turn off or silence all of your electronic devices because those can still be disruptive. And with that, the appellant is recognized for your argument.
Thank you, Your Honor. May it please the court, my name is Howard Sohn and I represent the appellate Antoine Stafford in this case. As Your Honors are aware, Mr. Stafford is serving a 20-year prison sentence based on what we believe to be insufficient evidence to support his convictions for the first 3 counts of the information. This was a joint possession case based on circumstantial evidence, and the trafficking amount of Utilone and the possession amount of methamphetamine were not found in plain view, but were found hidden inside concealed locations.
Counsel, circumstantial evidence is sufficient at this point, is it not?
It can be, if it's sufficient to, establish the case and independent proof that Mr. Stafford had knowledge and control of the location where the contraband was found. Yes, I agree with that. But in this case, we had no admissions, no fingerprints of any where the substances were located, no DNA, and no physical evidence. The evidence showed that Mr. Stafford was the property manager for the residence. He did not live there full time. The person who lived there full time under release from his brother was Camia McDougal. And even though the defense introduced photographs of Ms. McDougal packaging narcotics and counting money, she was never arrested nor charged in this case. And also, and more importantly, the bedroom where the concealed Utilone was found, inside the bedroom closet under the floor, police found a bag containing nail polish designs, lipstick, as well as pink clothing and pink shoes in that residence. But
did they need to prove that he was the only person with dominion and control over the residence?
I'm sorry, sir, the only person?
Did the state need to prove that he was the only person either with control or living there?
No, but they needed to prove he had dominion and control as well as
what types of items did they find that had his either name on it or some reasonable inference that could be drawn that were his?
Well, they did find his badge, his TWIC badge, and a bank card in a separate bedroom. But there was no contraband, no drugs, no narcotics located in that bedroom. So there was evidence that he had some access to the home. He ran his business from the home. He had his business card as well as a magnet advertising his landscaping business at the home. So there was, I'm not going to, mislead the court. There were items in the home that connected Mr. Stafford to his business.
And counsel, he had a history at the home, did he? I mean, isn't your first argument is sort of related to the Williams rule evidence, and essentially attempting to argue that was improper, but doesn't the argument you're making right now essentially eviscerate your very first argument that the Williams rule evidence was irrelevant? And
just to the contrary, Judge, and that's where I was going to lead to with my next portion of the argument to the Williams rule. The Williams rule deals with a search warrant at the same home 10 months earlier. The state in that case chose not to charge Mr. Stafford, presumably because they could not establish knowledge and control over the location, as well as where narcotics were found concealed in that location. If they had the ability or independent proof in 2019 to show that, he would have been charged. So basically,
Mr. Stone, how do you make that assumption? You argue that several times throughout your brief, but that's not the only reason the state might have chosen not to charge Mr. Stafford in 19, right?
Well, I can't see what else would cause them not to do that. They had it. There was no challenge.
Do you fish?
not very well.
Sometimes throw back a fish to let it get bigger. You sometimes use a fish to catch bigger fish.
I suppose that could be the position. We're going to try to get a larger
Well,
quantity, but
counsel, building on this line of questioning, the second question that we'd layer on top of this is why does that even matter in this case? Well, the state's motives for charging or not charging in 2019, how is that relevant here? In this case, they used it as Williams rule evidence, and the only question here is whether it was proper Williams rule evidence.
Correct. And my position is they seem to be saying that although he was not charged in 2019, and yes, Judge Harris, you're correct. My belief is they didn't have sufficient evidence to prove knowledge and control, that somehow now proves he had knowledge and control over what was found in 2020. And, if it's coming
well, counsel, I mean, I guess by the way, I'm not sure this is your best argument, but let's stay on this argument if that's what you want to argue. I don't understand how, given your client's defense, how the fact that your client was found, I believe in the record, it was either almost naked or fully naked in 2019 during the search, right, in the home.
Yes.
Correct?
Correct.
And where they found illegal narcotics, correct, at the time?
In 2019.
Correct, yeah.
Correct.
And then 10 months later, they have a very similar situation. They come in again, once again, he's either naked or almost naked.
Correct.
Right. So, if knowledge is an issue in the case, do you agree that knowledge is an element here?
Absolutely.
Okay. So, and given your client's defense at trial, that his defense was, I didn't know, I'm not, I don't have dominion and control. That's, why is there not an inference there a pretty strong inference, maybe even based on that Williams rule evidence?
Well, I mean, I think there might be, except as I'm going to delve into my final issue with the comments, the prosecution was trying to say that Williams rule evidence from 2019 is there to show knowledge, but in fact, the prosecution argued just the opposite in closing.
But this is a totally different.
Correct. Right. That's where I'm delving into, is that they basically they came in for one purpose of knowledge, but then they're arguing that's evidence of guilt. And
why don't you spend some time on your third argument?
Well, that's where the focus is going to be, because I agree with the court. That is the strongest argument in this case, because clearly we're not talking about one isolated comment in closing argument or opening statement. We're talking about 15 improper statements, starting in the prosecutor's opening statement and continuing virtually uninterrupted throughout their closing argument, both their initial closing and their rebuttal. And I don't have a legitimate explanation as to why the defense never made an objection to any one of these comments. And that's why I agree with the state. This is under a plain error, fundamental error standard, because there were no objections made. But clearly, I mean, for the prosecution now to suggest that.
Why don't you tell us give us the two, in your view, the two most egregious statements in closing argument. In your view, what were the two most egregious statements?
The two most egregious, obviously, is the last statement. Well, I take it back. I think the last three, where they're talking about he went to jail in 2019, it changed nothing, he learned nothing, no effect on him. Then the prosecutor following up where he says that he and his co-prosecutor see how this happens every day in a courtroom, how these houses are run, how the defendants try to outschool the police. Now you see it. And then the last statement, obviously, is he got away with it in 2019. Don't let him get away with it in 2020. But it also goes to the additional statements, because the prosecution is trying to excuse these comments, all 15 for the most part, as reasonable inference or fair comment. And yet the first 9 statements were made before the defense even got up there to begin their closing argument. And they're basically telling the jury, well, the police figured this out pretty quickly. They used their common sense. They knew he was guilty, so why shouldn't you?
So, counsel, to sort of short circuit this, let's say that this panel concludes, not all 15 probably were improper, but let's say this panel concludes that a substantial number of those statements were improper and some of them very improper. help us through the fundamental analysis, the fundamental error analysis. You do argue it in your brief, so you sufficiently raise the argument, but I'm not sure that you give us enough to get us home, right? Exactly what do we have to, how do we walk us through the actual analysis?
Well, the analysis is obviously.
Give us the rule and walk us through the analysis.
Well, we're obviously talking about harmful error, and we're talking about.
No, I'm not, counsel, I'm not sure. Your brief does confuse harmful error and fundamental error. I'm not sure those are the same thing.
Well, my understanding is we have to show that this affected the jury's verdict and this affected the outcome of the case. And without this, the result would have been different. And that's our position, that it's not the strongest case in the world on the facts. The Williams rule is marginal, although the court seems to be accepting that it was properly admitted. But you're talking about a trial where the defendant is entitled to a fair shot here. He's entitled to argue his innocence. He's entitled to argue lack of evidence. He's entitled to argue, So
counsel, in a world where the panel says, wow, the evidence against the appellant was significant, but the improper statements were egregious. Okay, so in that world, walk us through whether there's fundamental error.
The egregious, I don't think the court can find that the evidence was overwhelming against Mr. Stafford. I don't think the court can reach that conclusion. I think, again, if we had one or two statements isolated, where one in opening statement, one in closing argument, but this was a constant barrage, and I'm talking about the cumulative effect. Yes, we can pick out several statements, but he's being accused of money laundering. There was no money laundering charge. It's talking about a miscarriage of justice. The prosecution.
Let me ask you about that one. Let me ask you about that miscarriage of justice line, because I'm not sure I understand the problem with that one.
Well,
I've instructed hundreds of juries in the past, and don't we always tell them you have to follow the law? This is the law. If you fail to do this, your verdict will be a miscarriage of justice. I mean, that's specifically in the instructions.
Yeah, no, I agree. That could be interpreted that way. I'm not going to argue that point with Your Honor. I think that could be interpreted that way. But I think when you're telling a jury that the police figured this out pretty quickly, they used their common sense, they saw what was going on, you use the same common sense. That's not the standard. They're minimizing the standard. They're minimizing the reasonable doubt standard.
One way to interpret that statement, I'm not saying this is the only way, but one way to interpret that statement is, listen, jury, the police, they're not dumb. They use their common sense. They know what this means. And gee, if you don't come to the same conclusion, then you're dumb. I mean, is that how you think is that how you view the way the jury would have interpreted that?
That's the way I think a reasonable jury could interpret it, which is, they figured it out pretty quickly. It shouldn't take you long. And they use
what's wrong with you, jury, right?
That's almost what they're saying. It is like,
figured it out real quick. Okay.
But I mean, they're also, when the prosecutor is giving his personal view of the case, and he's talking about how his co-prosecutor see the stuff all the time, how defendants try to play the system, how they try to outschool the police. I mean, not only is that outside the evidence, there's nothing to suggest that was ever introduced in evidence, but this is the prosecutor basically telling the jury, you should listen to me because I see it every day. This is what happens. And how can you let that happen here? So it's a theme of the prosecution. I mean, plus they're telling the jury that the court allowed the Williams rule evidence because it proves knowledge. No. They can say to the jury, the Williams rule evidence came in to show knowledge, but to tell the jury that's why the court let it in.
That one's kind of a close one, right? I mean, I don't know.
I don't think it's so close because, like I say, I think they can tell the jury the 2019 evidence came in to prove Mr. Stafford's knowledge. That's going to be part of the instructions. But to say that's why the judge allowed it is almost like saying, well, the judge agrees. This is why it's here, because it proves knowledge.
Yeah, I mean, look, I think maybe a juror could view it that way. Do you see that? Do you agree that there's another way to view it, to impossibly interpret that as just saying, hey, look, the judge let this in because it's relevant to knowledge? Now, look, I agree. The assistant state attorney could have said it much more artfully, right?
I think much more. That's a nice way to phrase it. I agree. He could have said it much more artfully, but again, I keep coming back to the volume of the comments, again, if we're talking about one or two isolated comments, I probably wouldn't have raised the issue on appeal, or if I raised it, it would not be my strongest point. But we're dealing with something that takes place from opening straight through their first closing, straight through their second closing, and to say it's fair comment when 9 of the comments come in before the defense even makes their argument.
Well, that's why, Mr. Song, it would be much better, wouldn't it, if any of these comments were met with a contemporaneous objection?
Oh, no disagreement there. It's hard for me to come
having
up.
the same conversation.
I mean, as a lawyer that's tried a lot of cases, it's hard for me to come up and say how not one objection was raised to any of these comments by defense counsel. I can't come up with one other than they just, I don't know, and I'm not going to guess, but none were made. And clearly, in my opinion, this does reach the threshold of harmful fundamental error. I think it definitely prevented Mr. Stafford from receiving a fair trial. Just the cumulative nature of these comments, where the prosecution only acknowledges that one was improper, I think that defies a little bit of logic and common sense. So if the court has no additional questions, I'll save the remaining time for my rebuttal.
All right, counsel, we'll save the rest of your time, 5 minutes, 14 seconds for rebuttal.
Thank you.
And counsel for the appellee, you were recognized.
Thank you. Good morning. My name is Darren Shippey. I represent the state of Florida in this matter. I'm going to tell you, subject to the court's questions, that my emphasis will be on the first 2 claims. The third claim raised by the appellant, we have gone through in extraordinary detail to explain the context of the statements that were made, why we believe they were not objectionable or not improper, subject to the last comment, which we acknowledge was. There's a detailed analysis in the brief that would take a long time to go through. So my preference, subject to the court's questions, would be to address the first 2 claims. Do want to make sure the court is aware as it relates to the Williams rule claim raised by the appellant that we did file a week ago, a supplemental authority, and that is Wright versus State, which is out of the Supreme Court of Florida, found at 19 Southern 3rd, 277. The pages at issue that would be relevant would be 293 and 294. That's a Florida Supreme Court case from 2009. I'll discuss it a little bit later. So the Williams rule evidence, as you've already noted, is for a 2019 search warrant on
Counsel, just help me out here a little bit. I know you don't want to talk about the third issue, but it's pretty clear that's what the panel's concerned about. Walk me through the statement. We saw this stuff all the time, and we means the assistant state attorney. Defendants trying to school the police. Now you see it, jury. I mean, how? I don't understand how that's even remotely proper, counsel. Walk me through it.
As we've perhaps all acknowledged, and I have tried lots and lots of jury trials myself, perhaps I wouldn't say the things that were said by the prosecutor, seeing it for themselves.
I mean, that's saying, hey, jury, we see this happens all the time. Convict this guy because this happens all the time. And we know, we're telling you, we know it because we see it. I'm struggling to see how you say that's okay. So give me your best shot.
I'm not disagreeing with what the court says was said. On one level, we do have the virtually identical circumstances that were viewed by law enforcement in 2019. It would have perhaps been better for the prosecutor to compare things to prior events and then connect them in that fashion. I'm not certain that it gets to the point that it needs to have. I will also note that the defense counsel, for whatever reason, was very complimentary of the prosecutors in this case, announcing that they were, get what the exact words were, essentially smart, high quality, very good lawyers and knew what they were doing. So their perception of things may be different than mine, may be different from yours, which may have been a reason that they didn't object. As I said, it's always better for a prosecutor not to couch things in terms of their personal experiences or their personal opinions.
Well, look, I understand this wasn't you. All right. So don't take it as, that. But you're sitting here, you're essentially arguing that was not incorrect. I think you're taking the position that, look, gee, it could have been stated better, but it wasn't actually an improper comment. That's what I can't get my head around. I just can't read that to not be an improper comment. So that's what I'm trying to get at. Was that also an improper comment, or was it just inartfully stated? Because I think those are two different things.
I've written in the brief that matching up that comment with the argument is that they may have been fair comment. Number one, on the evidence that was heard. Once again, getting back to you cannot ignore in this case the virtually identical circumstances, identical parties from 2019 to 2020. The circumstances, literally, you could almost lay a one over the other. And inartfully stated maybe the way is a better way to say it, as opposed to was it improper. I mean, sometimes what's improper is it's a little bit like discretion. I might let somebody do something, somebody else might not let somebody do something. So I think one argument is that it could be fair comment on the evidence. With respect to I think you perhaps already addressed didn't take law enforcement long to figure that out. And that's the way I'm going to respond to it, is that I think based upon the prior incident in 2019, there's an argument that it's a fair comment based upon the evidence that the jury saw and heard.
How about the money laundering comment? Is that fair? Drug traffickers do this. It's called money laundering.
Poor choice of words.
You keep
However,
saying that, but this is what the jury heard.
I believe poor choice of words. However, you find close to $6,000 on that property in cash, which is an unusual sum of money to have. You find a substantial amount of drugs, and it came out in closing argument that the value of the drugs recovered, based upon estimates, was more than $80,000. You have someone who is operating a lawn care operating a lawn care business with his property outside, driving 3 very nice cars. Money laundering, although it is a crime, I think the public would generally understand that taking illegal money, i.e. the drug money in this case, reflected by the cash on hand, as well as the multiple cars this gentleman had, and truck I might add, out in the driveway or in the front yard, could reasonably be interpreted that.
So did they charge money laundering?
Oh, no.
Okay, because I don't remember seeing a charge for money laundering. So I guess
I think the fair comment is that he's saying he's dealing drugs. We know he's dealing drugs because of the trash pulls and the evidence and the fact that
right. But so why bring money laundering into it when that's not even charged? Why was that relevant or necessary?
Well, I can't speculate why the prosecutor made that choice of words. What I can say in defense of it is that we got a drug dealer who's obviously probably not reporting any money that he's earning from his illegal activities on his 1040 tax return. That's taking.
Where does that come from?
Pardon me?
Where does that conclusion come from?
Reasonable inference, I guess, from the evidence that he's a drug dealer. Most of them aren't reporting their income.
All this stuff might be fair game if you had charged it, but it's not charged. This isn't, we're going way beyond. Are we not?
Well, like I say, if I'm trying the case, I perhaps don't use those words, but I'm defending the words at this point in time. So,
but you can't just defend the words however you want. Look, this assistant state attorney was essentially saying, hey, look, his defense, the defendant's defense, right, was, hey, I had the $4,800 in cash because I was going to go buy some lawn equipment. That right? Am I wrong? Am I misremembering?
That testimony came out. You are correct.
So that was hey, look, guys, I know it's weird that I had almost $5,000 in cash sitting there, but I was going to go buy this lawn tractor or something, right? Well, look, I mean, you can certainly. I suppose the prosecutor could say, hey, look, jury, use your common sense. We found all these drugs. He's been there since 2019. We found all these drugs. he's got $5,000 in cash. You have to decide whether that makes sense, whether that makes common sense or not. But you don't have to then say, hey, by the way, he's money laundering.
Once again, you and I agree. If you're trying the case, if I'm trying the case, I don't use those words. But using the words, I would suggest to the court, and to get back to the fundamental error analysis, do the use of those two words over the course of a trial vitiate and undermine the entire trial? And I'll suggest to you, no, they do not, because
Let me ask you one way that they might.
Okay.
Knowledge is an essential element of the three charges that are at issue in this appeal, right?
there are three charges at issue on appeal. Yes, Your Honor.
And knowledge has to be proven on all three of those.
That is
And the
correct.
judge gave a limiting instruction every time this Williams rule stuff came in that it's only evidence to support or consider the appellant's knowledge. Yet in the closing, as I think Mr. Sona already said the judge let this in because it proves knowledge. Is that an accurate statement? Could the jury take from that the judge has already found that knowledge exists, that element has been proven? That's why he let this in?
I don't interpret it that way. And
Could
I
a reasonable jury interpret it that way? This proves knowledge.
first of all, I would suggest that the evidence was admitted for the jury to consider whether there was knowledge. So,
Absolutely, but the statement was made, it was admitted because it proves knowledge.
and I'll go, but the one way I'll respond is the jury is specifically told that what the lawyers say is not evidence. The instructions they are to follow. The law says it's presumed, unless there's some evidence otherwise, they follow the instructions. They will follow the instructions by the judge. So what the lawyer says, if we take issue with it, and I don't take issue with that particular comment because I think it's one way of saying the judge admitted this evidence, so you could consider, does it establish or help establish the defendant's knowledge of the drugs in this case?
Well, had he said it that way, we wouldn't be having this part of the conversation, would we?
I agree with you. And once again, I might say it differently, but once again, the judge's instructions control. The jury is presumed to follow the instructions. What the lawyers say is not evidence, nor is it in the instruction on the law. So
You keep saying how you would have argued it. We're not here to consider the case that you would have argued. We're here to consider the case that was argued here.
and I'm yes, Your Honor, and I respect that, and I'm defending it the way I believe it's appropriate to defend it, which is I think it's one way of saying the evidence was admitted to show knowledge. That's what I believe, Your Honor.
Counsel, I
Yes.
appreciate you. Again, I appreciate the fact that you were not counsel below, and that you're making the best argument you can here. I'd like for you to go through, assume for a moment that this panel concludes that there are multiple improper statements and that they are serious improper statements. Okay, just
Yes,
that.
sir.
So that's the assumption for this part of the argument.
All right.
If the panel concludes that, but the panel, for instance, also concludes, but gee, there was substantial evidence to convict, right? So you sort of have a case where there's strong evidence, but also very seriously improper statements, multiple improper statements by the state. Walk me through the fundamental error analysis in that situation.
All right. Well, the first thing I'll bring to the court's attention is that the jury was out for 1 hour and 15 minutes, according to the record. I think they went out at approximately 5 o'clock, came back at 6:13, 6:15, something like that. That's somewhat telling with a lot of evidence that was introduced, lots of witnesses that were called to testify, that the jury came back 1 hour and 15 minutes, found him guilty as charged. No lessers, guilty as charged. That's the first thing I'd ask the court to consider. Number two, it would be, in my opinion, a flawed analysis to place all the weight on the closing argument. In that respect, then, as you said, you're ignoring what the state considers to be overwhelming evidence in this case, starting with what happened in 2019, carries forward 10 months later to what happened in 2020. So in order to get to this vitiated the entire trial, and essentially the the state could not have obtained a guilty verdict as charged on 5 individual charges, that this closing argument outweighed the evidence is what you would have to find. And the standard is it vitiates the entire trial to the point that it's gone. I mean, you couldn't have obtained that conviction without your closing argument. And that's being disrespectful to the jury's verdict, and it's being disrespectful to the overwhelming evidence in this case.
Well, I'm not sure I'd use the word disrespectful, but I think I understand what you mean there. So let me ask you this. Aren't there, talk to us about some of the Florida Supreme Court cases on this point. Do you ever get to a point where, the closing statement is so egregious and so inflammatory that it almost that we don't need to look at how much evidence there otherwise was, because the state, and I'm not saying that's where we're at. I'm just asking the question, is that such a thing that it's so inflammatory that it's fundamental error, regardless of what maybe the other evidence might have been? Simply maybe because the appellate court can't tell at the end of the day what was influencing the jury, given how inflammatory the statement was. Do we ever get there?
You know, we as lawyers learn that there's probably some case out there that supports my position. So I would agree that there would be Supreme Court of Florida opinions that say, you know, the closing argument in this instance overwhelmed everything else. Almost if you're looking at it like, well, there's waves out there coming into the shore, and we got a tidal wave that just takes over everything, wipes everything out. Huge storm, if you will. So I would say that the possibility exists. I think part of the issue that I have with the defendant's claim is the assumption that every argument that he makes light of or highlights is improper. And ultimately, perhaps, if you winnow it down to whatever number the court apparently is thinking were improper, and perhaps we'll use the word egregious, does that minimal number, and we've acknowledged the last one was out of line, had no business in the process, and shouldn't have said that one. Does that represent the tidal wave coming into the shore that, you know, wipes out all the homes on the shore to the point that, you know, nothing exists anymore? And it's our position that the comments in this case, when you parcel them out, winnow it down, take those that you decide are improper, including our arguments to the contrary, do they represent the tidal wave coming in, wiping out all the homes on the shore? So once again, the standard, the law is not in dispute. You know, it's got to vitiate the entire trial. We learn as lawyers that not everything is A plus B equals C situation. There is some room for discussion, some room for consideration. So it's the state's position that we acknowledge the last comment. I have no defense to that one. That even if you add some of the others that you talked about, whether it's the money laundering or anything else that you mentioned, if those couple, 3, whatever it turns out to be, the number that you may decide, do those outweigh all of the evidence and undo the entire trial and the jury's verdict that only took 1 hour and 15 minutes to be determined? And we would suggest no, they do not. So, well, I'm down to 2.5 minutes. We spent the time on the third claim, and hopefully I've answered each of the judge's questions in that regard. I'm not certain that it does a whole lot to address much of the merits as it relates to the other 2 claims, but I would like to leave the court in a discussion.
We seem to have lost audio.
Thank you. I would encourage the court to pay attention to the physical evidence that was introduced in this case. This was a sophisticated operation by this defendant. There's a computer that's depicted in the photographs, displaying video surveillance cameras. Talking about knowledge, there's a tray on the counter that's right next to the 2 lanterns and the Clorox box. It's big tray that's got marijuana on it, and each end of it's got the word Twan, T-W-A-N, short for Antoine. The notes on the refrigerator door to him are dry. The two huge signs on the door, on the side of the refrigerator that are there. The Navy Federal Credit Union card with his name on it, the TWIC card, that's short for Transportation Worker Identification. And leave you with this, that he was twice found naked or close to being naked with the same woman at the same property. Two people had keys to the premises. That was him and Ms. McDougal. Obviously, his vehicles and lawn care equipment. His fingerprints were found on scale and jars, and a jar, excuse me. Perhaps could have been used with respect to the Utalone that was discovered. And more importantly, as he's being taken into custody and placed in the deputy's car, he makes a statement to his neighbor to watch out for my house. So we would suggest that all of that indicates there's no issue with respect to knowledge, dominion, and control. We'll rely upon our brief and the answers that we've given you with respect to the third claim. And thank you very much for the court's attention today.
Thank you, counsel. Okay, counsel for appellants. Looks like we have you all set here on the clock, 5 minutes and 14 seconds. You're
Thank you.
recognized in rebuttal.
Thank you. The state's initial comment that the prosecutors were experienced, did a good job, and knew what they were doing, that doesn't support the state's position, but to the contrary, shows that this was intentional. We're not talking about a prosecutor that's been in the office for 6 months and this is their first felony case. These were experienced trial prosecutors. So we can't go say, well, they didn't know what they were doing. They weren't experienced. They weren't trained. They knew exactly what they were doing. They knew exactly what they were saying. The fact that, the state wants to say, well, you can excuse it because it's a poor choice of words. That's not an explanation or an excuse. As Judge Harris pointed out, we're not dealing with how this case could have been handled differently, because I'm sure Mr. Shippey would have handled differently from the state side, and I certainly would have handled differently from the defense side. But we have a record and we have a poor choice of words.
Counsel, give me your best case or two on fundamental error in closing argument that you think that we ought to make sure that we've read 3 times before we decide this case.
The case I cited for the court in my brief, the Cardona case from the Florida Supreme Court, I believe that's a critical case in addressing fundamental error. And also the case from this court, Caraballo, which I cited on the last page of my initial brief, says fundamental occurs in closing when the prejudicial conduct in its collective import is so extensive that its influence pervades the trial, gravely impairing a calm and dispassionate consideration of the evidence and the merits by the jury. What Mr. Shippey told this court is what lawyers say is not evidence. That's true, but I'm sure he's not saying that gives lawyers from the state carte blanche to say whatever they want, because there's going to be a jury instruction later to say it's not evidence. And the fact that the jury was out for a short period of time doesn't support their argument either. That jury could have been out for a short period of time because of this bombardment of improper comments. I mean, they're basically being told the things we've talked about, that the court is basically instructing the jury, that's why I let it in. It's, the judge let it in because it proves knowledge. That's an issue for the jury, not for the prosecutor to say has already been determined. The whole common sense part, the money laundering, the prosecutor giving his personal belief as to what he sees in court every day. I mean, prosecutors have some air of authority in court. They're officers of the state. They always tell that to a jury, that we represent the people of the state of Florida. They have some authority. And what they're telling a jury, we see it every day. These defendants try to school the court. They try to school juries. Don't let him do it to you here. That's what he's doing here. I mean, that's what they're talking about, that he went to jail in 2019, didn't learn then, still hasn't learned.
Counsel, I think that the one sort of issue here is the, your opposing counsel referred to the general rule, the language of the general rule several times, and incorrectly so. The notion that to the extent that the verdict of guilty could not have been obtained without the assistance of the alleged error. And in some way, I'm not sure this is a correct way to interpret that statement, but in some way one might interpret that statement as saying, well, as long as there was competent substantial evidence of guilt, then the verdict could have been obtained, right, absent the alleged error. But I assume you don't think that it's just simply a competent substantial evidence analysis, right?
Just the opposite. No, I think what they're trying to say by their argument is, well, we had evidence to show his guilt, so basically don't pay attention to what the prosecution said in closing argument. And again, if this was one or two isolated comments, we probably wouldn't be here addressing this issue. But this is not one or two isolated comments. It takes place from the get-go in their opening statement all the way through their rebuttal closing argument. And in all candor, it gets worse and worse the more they do it, probably because they felt emboldened because there's no objections. And if a defense lawyer is saying the prosecutor's not going to object, let me keep going, and vice versa. If objections were made at the initial stages, most likely the prosecutor might have said, yeah, maybe I shouldn't say that. But they felt emboldened. It was a bombardment. It clearly invaded the province of the jury. It vitiated this entire trial. It cannot be excused or condoned as harmless.
Counsel, do you think it matters that some of the statements were connected to Williams rule evidence as opposed to just sort of completely unconnected statements? Well, the fact that some of the statements were connected to evidence that was presented.
Well, I think, as I stated in my argument, I think the Williams rule evidence coming in, which the court seems to agree was.
Well, let's assume for a moment that the Williams rule evidence was proper so long as it was only there for knowledge.
Right. But I mean, I think the issue on the Williams rule for the 2019 was that he was arrested or found in the house where drugs were located. But taking it further and saying he went to jail, he learned nothing, he didn't change, he kept going. Is that connected? I guess in a larger scale, yeah, it's connected in the sense.
Well, that statement wouldn't make any sense if the jury didn't know about the 2019 stuff, correct?
Yeah, I mean, without that, I'm sure there'd be no reason to bring this up. But my
All right,
position
counsel,
is so pervasive.
Your time has expired. Thank you for a very good argument on both sides, and we are in recess.
Thank you for your time. Appreciate it.